morning. Please be seated. This is the time set for oral argument in the matter of Grand Holdings et al. Versus Peoria, or civil number 19-0379. Each side will have 20 minutes within which to present their arguments here this morning. Appellant may reserve some portion of that for rebuttal. That's up to you to keep track of the time in that regard. We have read the briefs. We have been through the record and conferenced the case. So we're pretty familiar with the underlying facts and issues and arguments that have been raised, at least in the record and in the briefs. So please keep that in mind as you make your comments to us here this morning. With that, appellant may proceed.
Thank you, Your Honor. My name is Jim Santos. I'm with the law firm of Jennings, Housen, Cunningham. I represent the appellants in this matter, Grand Holdings. There are two of them, different entities, but they combine own property in the city of Peoria. On this property is located what was once a thriving Smitty's grocery store and is now a boarded up concrete block building waiting for the next chance for redevelopment.
Wasn't there a demolition order that was issued?
Yes, and that's certainly having a constriction on development. Like anybody who's contacted us recently to reuse that property is being told by the city of Peoria that they can't because it's going to be torn down. But I'm here today to ask you that we reverse some of those orders so that the next person who knocks on our door to reuse the building as a charter school or a church or a health club at least can sit down with the city of Peoria and talk to them on a reasonable basis to see whether or not the city codes can allow them to do that.
I was just wondering if there was a stay order in place.
No. There is no stay order. They fought our stay order at the trial court level. They were so eager to move forward. But no, there is no stay order and the building remains in place.
All right, so your clients haven't complied with the order?
We have not. Your Honor, we're here today because we're appealing from the Building Board of Appeals decision. This one paragraph masterpiece of administrative hearing decision, which of course, as we all know, includes no findings of fact, no conclusions of law. All they say is they accepted their staff recommendations and they ordered the building to be demolished. At no point in time was there ever an evidentiary hearing. At no point in time was there ever any type of semblance of due process. But I think, and we said that all in our briefs, and I think we've said them well in our briefs. Let me focus on three issues. Three very simple legal issues. First of all, the International Property Maintenance Code, Section 107.2, when it describes what type of notice and order can be issued, is very specific. It says any such notice of orders, the citation that Grand Holdings received that told them to tear down the building from which they appealed to the Board of Appeals, that order shall, in writing of course, and shall include a correction order allowing a reasonable time to make repairs and improvements required to bring the dwelling unit or structure into compliance with the provisions of this code. And on its face, we know that the notice and order given to Grand Holdings did not include a correction order allowing a reasonable time or any time, or even require correction. All it required was demolition. So just on its face, we know that the order that was served upon Grand Holdings did not comply with the mandatory legal requirement of Section 107.2 of the International Property Maintenance Code.
Counsel, before you move on from that argument,
Yes.
Did you raise that argument below?
Oh, absolutely. As a matter of fact, that was the basis of the appeal. When Grand Holdings filed their initial appeal, they specifically stated that while the building may require some repairs, it is no way unsafe, and it's not unreasonable to repair the structure either. That was the basis of the appeal, that repairs should be allowed, and nothing short of repairs should be allowed.
But didn't your client say, I'm not going to do the repairs? Unless I have a tenant, I'm not going to do it. Wasn't that what?
I don't know where you found that in the record, Your Honor, because there is no record. Here's what my client said in this notice of appeal. We strongly disagree with the will and inspection assessment and the conclusions reached by the code. Officer Eager, while the building may require some repairs to roof penetrations, it is no way so unsafe as to require demolition because it's unreasonable to repair the structures, as per Officer Eager's notice. So that's what they said in writing. That's part of the record. Nothing else is part of the record because there was never a hearing, no transcript, nothing for you to evaluate to see what was said or not said.
Well,
But
you're
even
asking
if he
us-
did
if
say,
you're saying-
when did he say that?
Well, if you're saying here today that the order should have given him some time to cure, a cure period.
Well, Shall.
That's what you're saying is the flaw in the order, correct?
yes.
Has there been any effort to cure?
Oh, I'm sorry, Your Honor. Nobody
You're
asked us
saying
to.
the flaw is he should have had time to cure.
Yes.
The order's been out for some time. Has he effected any cure?
What cure, Your Honor? It says that the repair order shall allow reasonable time to make repairs and improvements required to bring the structure into compliance with the provisions of this code. All we have is a demolition order. That's all we have. Let's say I put $100,000 of repair into it tomorrow. Is it going to be demolished the day after that? So you just can't do that, and that's why the code says shall, and that's why the requirements are there. You don't put the horse or the cart before the horse. You have to first ask them to correct. And whether or not someone says I don't intend to, first of all, they don't say when he said that. He also said he doesn't intend to have the building destroyed because it's a valuable asset on his property. Yet
Counsel,
they ordered it destroyed anyhow, so it's not like they were
Counsel,
waiting to listen
let me
from
go
him.
back to the
Yes, Your
International
Honor.
Property Maintenance Code that you cited earlier and you rely on for the proposition that there must be an opportunity to correct. Doesn't that code also allow for the order to demolish a structure in certain circumstances, including when the building is unfit for human habitation or occupancy, which is what was found in this case? Isn't that also a permitted result?
A result, yes, but we have to go through the procedure. First, you issue the citation and the corrective order. If the corrections are not done in full or do not satisfy the issues, you're right. The end result can be something different. What if, no matter what corrections you try, the building is still structurally unsound and can't be saved? Well, at some point in time, you have to give up your corrections. But the 107.2 says the initial order shall have a corrective period, and a correction order and a reasonable time to make repairs. This one does not. So, yes, I can envision some buildings that can't be repaired.
Before we go any further, was this building ordered demolished because it was structurally unsound?
Oh, absolutely not. They repeatedly have told us that there's no structural problems at all with this building. They're not worried about that. It's hard to know exactly what they're worried. They say safety. Well, the building's been sitting there for 17 more months. I don't know how much safety issues have happened in the last 17 months. Probably the same number that happened beforehand. None. It is sitting there just like it has sat there. No different than Hayden Mills has sat there since 1912 when it was originally constructed as the largest concrete building in Tempe at the time.
So then let's address the issues on which, or the arguments on which the order presumably rests. So if it's not due to structural unsoundness, then it's unfit for human habitation or occupancy?
Well, the order is based upon the staff recommendations, Your Honor. That's all I can tell you that the board decided. That's the only word that we have from the board.
On what staff recommendation specifically?
They don't tell us, so we don't know. And we don't have any other words from the board telling us what the board considered and decided. We have people who are in the audience, just like these folks here, can tell us what might have happened, but they're no better at it than anyone else here to tell us what you are thinking, what you are deciding. We have to wait to hear from you on that issue. And we haven't heard from the board on what they considered, what they decided, what evidence they thought was valid or not valid. Well, they had no evidence. They didn't have testimony. They had an unstamped engineer's report, maybe. Not even that. They had a PowerPoint version of it. So the board didn't have any true evidence before it. If I may, let me move on to my second issue that I think is also a clear error of law, is that the Arizona legislature has provided express legislative authority on how to enforce code in the cities. It's found at ARS section 9-500.21. And that is pretty streamlined procedure. It allows for hearing officers or judges They have to follow the the rules for civil traffic offenses, which of course includes rules of evidence, rules of procedure, rights of cross-examination, right of appeal.
What is the civil offense? What civil offense is the argument against?
Well, 9/500.21 says the hearing officer may order abatement of the violation pursuant to 9-499. That is the remedy that they were seeking, abatement of the violation. So the hearing officer can issue the exact order that they were seeking under 9/500.21 as they're allowed to pursuant to 9-499. In the answering brief, they cite 9-499 as authority for why they can do these things. Well, you're right, but the method of enforcing that authority is 9/500.21. One of the critical issues there, of course, is under the civil traffic rules, you have the right to trial de novo if there's an inadequate transcript of the proceedings. We didn't have that here. You also have the Superior Court is granted appellate jurisdiction pursuant to ARS Section 12.124. We did not have that here either. There was no statutory right to appeal from the City of Peoria's position. So they should have used 9/500.21, 9-499. That's how they could have and should have, at least how they were legislatively authorized to do this type of an action, and they chose not to. They chose their own procedure. I get it. And we cited the Falcone brother case where the City of Tucson chose its own procedure as well. And it didn't match the statutory regulations and requirements that otherwise exist, and the court found, well, when there's a set of statutes telling you how to resolve your dispute, and you go off on your own and concoct your own, that's not statutory authorized. Same result I'm asking this court to reach as well. And the third issue I want to raise is the due process of law issue. And I think that's, of course, very important. The City of Peoria's public body meeting procedure states quasi-judicial hearings shall be conducted in accordance with the principles of due process, and legal counsel to the public body shall advise the public body in that regard. Constitution, Article 2, Section 4, no person shall be deprived of life, liberty, or property without due process of law. Okay, so we get it. We're aiming at due process.
So what specific due process do you say needed to occur? What specific thing did the board need to do that it didn't do? Because you're asking for the relief.
You're right.
And you're saying judges tell them, do this.
Well, I'm just a lawyer. So all I can do is tell you what other legislatures have said when they pass laws, or other people like you have said when you issue your decisions. So let me tell you what another panel of the Court of Appeals has said. What is due process in an administrative hearing where the only statutory requirement that we can craft on how the procedure should go is that due process shall be followed? Well, that's the Duell decision. And the Duell v. Arizona State Board of Deaf and Blind is an administrative hearing. Same here. The statute described the hearing procedure that Duell was entitled to due process protections provided by the board. Wow, isn't that pretty darn close to what we just have here? Hearing shall be conducted in accordance with principles of due process. So when I'm looking at that decision, I think I know what at least other courts have said is due process for an administrative hearing where the only requirement is that due process be applied. And that decision, it's very short. It's only a couple pages long, and it tells you exactly what should have happened in this case.
But counsel, doesn't due process vary depending on the type of case that we're considering? And in Duell, wasn't that a public employment type of case?
It was a post-termination hearing, Your Honor, yes. And my father was a teacher. I love teachers. I can tell you that the monetary amount of dispute, which is what lawyers sometimes think about, on a teacher's termination and loss of salary is far less than what we're talking about today. And far more difficult to replace than what we're talking about today. So if you're comparing apples to apples, if you're talking about the teacher in Duell and his salary, loss his salary from the school district compared to the loss of an 80,000 square foot building, monetarily we're talking magnitudes much greater in the loss of an 80,000 square foot building for dollars. And to replace it, heaven forbid,
Do we
that.
have to judge the right to due process based on the dispute? That's not
Well-
a standard that we are to follow.
Well,
Because due process is due process. It's a fundamental right.
It is a fundamental right, but can you have a little bit lesser due process for a $5 parking ticket? I think we've said yes. If your life is at stake, I think we say greater. So there can be differences. But I've not yet found one case that says property can be taken from an individual or corporation without at least some fundamental due process rights, including disclosure of evidence beforehand. Yes, Ron?
Is this a taking or is this an exercise of police power? Because there's a recognition of a difference. A taking involves a process and compensation, reasonable compensation.
A proper taking requires that.
And-
Improper taking does not, as we see here.
But a police action does not trigger the same.
I have not read any case that says that people accused of crimes by police have any less rights of due process than what we were asking for here. Fundamental rights.
I think Judge Geis was referring to the police power of the government to regulate business for the health and protection of the community.
Fine.
Okay. Well, how about regulating contractors for the protection of the public? That's the regulation procedure. In Gordon v. Arizona Register of Contractors, the court found there was proper due process because the contractor in that case had the right to present evidence, testified at an evidentiary hearing, and cross-examine witnesses. How about
Well, as long as we're talking about cross-examination, didn't Grand Holdings have the opportunity to call witnesses
no.
if they wanted to do that, present evidence?
Oh, call witnesses. No.
They could not have called the writer of the Golden Report?
Well, first of all, due process requires the city of Peoria to give us the due process. We don't have to take it. Outside those cases, you can't say it's our fault for them not making their witnesses available. But second of all, no, there's no right to subpoena at all in this procedure. There's no way to compel witnesses to attend. As a matter of fact, we didn't even know what witnesses would or would not come in, which in the Duell case it says disclosure of the witnesses is part of due process. Here, Grand Holdings shows up, and could be anybody who shows up on the other side and presents their PowerPoint presentation. If you were to assume that they were going to actually make a case for themselves and they should have brought the witnesses they needed, in fact, Grand Holdings would be stupid to call a witness that supports the other side's case if that other side's witness is not showing up. That is how the hearing would go. The other side would have no witnesses at all, and Grand Holdings would show up and say, well, I guess they have no evidence, I'll sit down now.
All right. Well, your client was present for the inspection, for the Wilden inspection, correct?
Yes.
And they were served with the order,
Yes.
and they received the report in advance of the board hearing.
Yes, the report was not evidence. They used the PowerPoint presentation to summarize parts of the report and parts of other things that aren't in the report. But yes, we had the report before the hearing.
Okay. And so is it your position that you did not have the opportunity to present objections and arguments at the board hearing?
No, he did. He showed up with his own expert report and ready to go full speed. That doesn't excuse the fact that the city didn't bring anyone to testify. I mean, that's why Jack Levine had his administrative hearing reversed, because the state bar used a report without the witness there to be cross-examined. If I could reserve the last few moments of my time, I would like to do so.
Thank you, Counsel.
Thank you.
May it please the court. My name is Amanda Sheridan, and I represent the appellee, the City of Peoria. The court is exactly correct that this case raises the issue of whether Peoria had the right to exercise its police power in ordering Grand Holdings to demolish an unsafe, dilapidated building which has sat vacant for 20 years and had numerous code violations spanning the course of that 20 years. The lower court, which examined the record before it and considered what the Building Board of Appeals considered, decided that yes, in fact, Peoria had exercised its police power properly, and also that the board did not act arbitrarily or capriciously and did not deny Grand Holdings its due process rights. I'd like to address first a few of the points made by Grand Holdings. I completely disagree that this issue that he just raised, that I'm hearing for the very first time today, this violation of the IPMC Code 107.2 and notice, and whether that was properly complied with, was ever raised at the lower court. And in fact, I just skimmed the opening brief before this court, and I didn't see it in that as well. So I would argue that that issue has been waived. Turning now to some of the other more important points. I'd like to focus on a few of the findings of the Superior Court, which I feel like have been lost in the briefing here. The IPMC has been adopted into Peoria's city code. That was found by Judge Thomason. That an inspection was done and a report was issued, and that Grand Holdings got the report. Judge Thomason stated that the report and accompanying pictures make it evident that the condition of the building is, to put it mildly, horrible and very unsafe. This is a dilapidated building in horrible condition that sat vacant for over 20 years. Mr. Hasid testified at the hearing that Grand Holdings did not intend to fix the IPMC violations until it found a tenant. He admitted... I'm sorry, Your Honor?
What hearing did he testify at that he said he did not intend?
At the 11/2018 hearing before the Peoria Building Board of Appeals.
And is that in the minutes? Where do we find that? Because he says there's nothing in the record. So where is it in the record?
It's actually a few places in the record, Your Honor. Your Honor, if you look at the minutes that were issued after the board hearing, there's one spot where it says, Mr. Ron Hasid stated he is looking for the right tenant to lease the property and improve it. Then also, if you actually look at the complaint that was filed with the Superior Court in the special action, in paragraph 45, Grand Holdings states, the uncontroverted testimony was Grand Holdings property and existing structure could undergo similar renovations once a tenant was identified and under contract. Now, that isn't a direct quote saying, yes, we agreed that we weren't going to fix that until we found a tenant, but it certainly is suggestive of what the city of Peoria has understood for 10 years, that Mr. Hasid was going to wait until he found a tenant to make any of these corrections to the code violations. The court also found that Grand Holdings was treated fairly and that the ruling of the board was not arbitrary. And he said, quote, Grand Holdings just disagrees with the decision. The board's decision was supported by considerable evidence. And perhaps most importantly, Grand Holdings did not even refute the code violations. Mr. Hasid could have testified about the code violations and could have disputed them if he felt that any of the material presented at the hearing was inaccurate. He did not. Rather, he simply contended that the building was structurally sound and should not be torn down. Turning to whether Peoria had statutory authority to do what it did, I think that's actually fairly clear, but I will go over it because Grand Holdings seems to suggest that they did not have statutory authority. If you look at ARS 9500.21, which they argue Peoria failed to follow, it states a city shall establish procedures to determine violations. Then it goes on to say that may include, and it gives a list of things that the city may do as part of their procedure. But the only requirement, the only shall, is that the city have a procedure itself. And the city absolutely has a procedure. The procedure is that they issue a notice of code violation, that's a citation, like a speeding ticket. Then the person has the right to appeal. They appeal that to the Building Board of Appeals. The Grand Holdings argument said that this was not an independent body. He referenced, I think the word he used was their employees at the board hearing. That's just simply false. The board is a completely independent body made up of private citizens who volunteer their time, and each one has some kind of expertise in these types of code violation issues. So there's someone who's familiar with fire codes, there's someone who's familiar with construction, et cetera, et cetera. But all of those people are completely independent from the city of Peoria. None of them is employed by the city. So in other words, absolutely Peoria did comply with 9500.21. We had a procedure, it's undisputed. The analysis shouldn't stop there though, because 9500.21.4 also states that a hearing officer may order abatement pursuant to 9499. And that's what we have here. So if we turn to 9499, under A, and I'm quoting in relevant part, the governing body of a city by ordinance shall compel the owner of a property to remove from the property any other accumulation of filth, debris, or dilapidated buildings that constitute a hazard to public health and safety. In other words, this is the exact statutory authority that Peoria relies upon to require abatement of the building. And in fact, the statute seems to suggest that cities are required to have owners of dilapidated buildings remove that building because they constitute a hazard to public health and safety. And then there are some further requirements we can look at. 9499A goes on to state that an ordinance shall require written notice to the owner. Well, it's undisputed here that Grand Holdings did receive written notice. Provisions for appeal of both the notice and any assessments or fines. We can also check that box. It's undisputed that Peoria provided Grand Holdings with an appeal process which took place on November 20th, 2018. That's it. Those are the only true requirements under 9499A.
Does the list of items you mentioned, it certainly it's your position that the city can issue an order directing the landowner to obtain a demolition permit and demolish a building if that in fact is the abatement. Is the board required to identify why the building cannot be remediated? And if it can be remediated, to provide direction to the landowner as to what steps need to be taken to remediate it?
Your Honor, if you look at the notice in order to abate, there are several options that are given, and one of the options is to allow a certain amount of time for the owner to take some corrective action. In this case, I think because the history of such between Peoria and Grand Holdings was such that Peoria was already aware that Mr. Hasid had no intention of correcting any of these code violations, and had already gone through several periods where he had had prior code violations that had never been fixed. They had gotten to the point where they said, well, we've been dealing with this now for 10 years. We're going to now order the abatement and demolishment of the business. Now, it's also true that if Mr. Hasid had shown up at the hearing and said, here's my timeline for correcting all of these deficiencies. I've hired a contractor, he's ready to start work on X date, I'm willing to put in X amount of dollars, and gone through that with the board, the board very well could have overturned the abatement order. And in fact, there were several affidavits that were attached in the lower court stating that had happened numerous times at Building Board of Appeals hearings, that an owner had showed up with a plan to correct, and that that person was then given the opportunity to correct. Here, Mr. Hasid came to the hearing and said he didn't intend to correct any of the violations until he got a tenant. So then the board was looking at a situation where it could sit here for another 10 years and have this building in this condition without ever being corrected.
But Council, don't think you quite answered the question in terms of what the board can do. Can the board go straight? I hear your arguments for the reasoning behind the board's decision to choose that the building be demolished, among other options that they had. But are there any? Is that option available regardless of the circumstances?
I'm not sure I quite understand.
In other words, even without a history of 10 years of dealing with Mr. Hasid, could the board order the most severe measure of demolishing rather than the less severe of ordering that the building be brought up to a condition that was acceptable?
Well, the board's decision is always based on what transpires at the hearing and what evidence is presented at the hearing. So
I'm asking in terms of due process.
Sure.
Any of these outcomes are available to the board regardless of their findings.
No, I wouldn't say regardless of their findings. I would say that their findings, so the staff person goes in and does the inspection, notes all the code violations, and then makes a recommendation.
Right.
And that recommendation was based on not just the condition of the building today, but it was based on the condition of the building in the past 10 years and also what had transpired between Peoria and Mr. Hasid. And then that was what the board was basing its decision on. It would be hard to say whether they could do that in a vacuum because they are always going to have some evidence presented to them about what the history is between the person who owns the building and the city. And that's just part of the hearing process. So could they do that? I guess it's possible. I think what you're implying is that wouldn't be due process. And I would agree with you, that wouldn't be proper due process if they just ordered a building to be torn down with no basis for believing that there was a reason for it. The city can't come in and say, you need to tear down this perfectly sound building that has no code violations. We just don't like it. The city couldn't do that. So, and that's not what we have here. We have here a history of those violations, all of which were presented to the board. The board made its decision based on a plethora of evidence about this property itself.
Right. My question assumed that there is some violation, but whether the severity of the violation should dictate the remedy that ought to be applied. But
I think that is a consideration that the board makes. Yes. Turning to the due process considerations, we disagree with Grand Holdings' premise that due process is a fixed standard that has to be, addressed every single time in the same way with the same rights. Due process minimally requires adequate notice and an opportunity to be heard. And case law makes that very clear. The Matthews versus Eldridge case, cited by Grand Holdings, stated that before being deprived of a property interest, there's a right to be heard at a meaningful time and in a meaningful manner. But it also says due process is flexible and calls for such procedural protections as the particular situation demands. And unlike some legal rules, it is not a technical conception with a fixed content unrelated to time, place, and circumstances. So really, due process means that there has to be that notice and there has to be an opportunity to be heard, a meaningful opportunity to be heard. And we argue that that is what occurred here. There was plenty of notice given. There was actually 2 months between the time that Mr. Hasid was served with the notice of hearing and when the hearing actually took place. There was plenty of time for him to retain counsel. There was plenty of time for him to figure out what witnesses he would like to call. There was plenty of time to him to figure out any questions that he would ask of the city. He had that opportunity.
And when you say that he would be able to call witnesses, is that appearing at the public hearing and talking?
Yes, Your Honor.
Were they subject to time limits?
No, Your Honor.
So he could have had somebody talk for 2 hours on this issue?
Yes, Your Honor.
What about, I'm sorry, you said that he had the opportunity to call witnesses. and question the city inspector, or who would he have questioned?
Yes, Your Honor. So the person who, there were actually several city employees present who gave testimony at the hearing itself. He could have questioned any of those. So Jack Stroud was the primary presenter of the evidence to the entire, board, to the board. So he could have asked Mr. Stroud questions. He was the one that used the PowerPoint that Grand Holdings complained about. That PowerPoint, by the way, I would say is akin more to a PowerPoint for an opening statement. It wasn't evidence itself. It was just a summary of the evidence that the city was relying on. So it was a summary of evidence, all of which Grand Holdings had before that hearing. The Wildan report, fire code violations that had been called in previously, complaints against the property, all of which Grand Holdings was well aware of in its 20-year history. The cases cited largely by Grand Holdings either actually support the contention that notice and an opportunity to be heard are all that's required, or they're distinguishable because, again, if you're going on a case-by-case factual analysis, there's going to be a different standard for due process when we're talking about someone losing a job versus somebody losing a building. And Grand Holdings has disputed that it is taking the property, and I agree with Judge Goss that here there's a difference between a taking under the takings clause and an exercise of Peoria's police power. We are not taking the building, and we are certainly not taking any real property. Grand Holdings will still own the underlying real property and be able to develop it as it sees fit. We are only requiring that it knock down a dilapidated building which is unsafe and a risk to the public.
Why does and they've argued that Section 9/50221 of the state code applies, and there should have been a hearing because this was a civil offense. Why doesn't it apply?
Well, actually, I argued that it does apply, but the only requirement is that there is a procedure. It actually doesn't say in 9/521 that you have to give a hearing that meets any other requirements. It simply states that a city who is fining someone or giving them a violation of some ordinance has to have a procedure for then dealing with it.
What is the procedure for the underlying code violations?
Well, in this case, the procedure was notifying Mr. Hasid that we were going to be doing the inspection under the IPMC code, showing up, giving him the opportunity to show up at the inspection, going through that inspection, issuing the Wildan report, and then speaking with him about those issues. Lastly, I'd like to say that even if the court's persuaded that there were any procedural errors or irregularities in Peoria's Building Board of Appeals process, those errors did not result in any prejudice to Grand Holdings, because Grand Holdings admitted, both through its representative at the hearing and through its own briefing, that they had no intention to correct the violations until it found a tenant. And if you look at the Pavlik versus Chinley Unified School District number 24 case, for this proposition, it states that as long as the other side was afforded due process, defects in proceedings that did not prejudice his rights do not require upsetting the administrative decision. And at most, that is what we have here. Some minor flaws in Peoria's procedure that Mr. Hasid complains of, but did not ultimately deprive him, Grand Holdings, of its rights. Unless there are any other questions, I'll sit down. Thank you, Your Honors.
If I may, I'll move quickly with some points I'd like to raise. First of all, mention of the code section 107.2. Peoria couldn't find it in our opening brief. That's why their answering brief didn't mention it, and why my reply brief at page 29 said, in our opening brief, we talked about section 107.2 at pages 40 and 42. In their answering brief, they don't mention it. That's a confession of error. And that's how I addressed that in the opening and reply brief. Number two, the history of code violations. Give me one. You've read the record. Give me one example. There is no. This is the first and only citation issued under the International Property Maintenance Code. This is the first time a repair requirement was required. And in fact, Mr. Hasid in the Grand Holdings Appeals said at best, it requires some repairs. It shouldn't be demolition. And they say, oh, well, he's never intended to repair it. I don't intend to repair anything until I'm ordered to sometimes. But if I'm ordered to, I'll follow the court's order, subject to appeals and things like that. I mean, we always have that right. She's mentioned that it was the opportunity to negotiate with the Board of Appeals. Mr. Hassid could have said, you know what, if I repair it and I do this, wait a minute, that's not an appeal, that's a mediation. The only thing he was appealing was the order to demolish. And the fact that they can see that you can negotiate repairs with the board means that demolition is not needed. Repair should have been done. And there's nothing in the rules of the code or the paper that Mr. Hassid received that says he had the right to show up to the Court of Appeals and negotiate with them. If so, I'd be happy to open negotiations right now with the three of you. Now, as you can see, that was the appellate board. You're the appellate court. And I had two more points, but I've run out of time, so I'll sit down now.
Thank you, Counsel. We appreciate the arguments and briefing of counsel in this matter. We're going to take it under advisement. We'll issue a written decision in due course. With that, we are adjourned. Thank you.